I mean, if somebody finds a gun and they're picking it up and on the phone to call the police to say, hey, I found a gun, come and pick it up. Legally, is it possession? But this is not what this law is meant for. Am I wrong? And I understand state why you're reducing it, but do we have any proof of this? I'm telling you all, if there's proof of what he's saying, that he was on the phone, and it appears that there was the gun didn't have any, wasn't loaded or anything. 25 CR 005952, State versus Frank Garza. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Donald Wilson for Mr. Garza.
And are you Mr. Garza?
I am.
Counsel, have you received all discovery and did you review that with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Counsel, I see in the notes that there was a competency evaluation done.
Yes, Your Honor. It was, and it came back that he is competent, and I agree with that.
All right, and he's already been deemed competent by that court and that judge?
That's correct.
All right, thank you. Mr. Garza, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are not. We are proceeding for the lesser included attempted possession to make this a third-degree felony.
No objection, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the lesser included offense of attempted unlawfully carrying a weapon with a felony conviction as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of attempted unlawful carrying of a weapon with a felony conviction. They're asking that your punishment be assessed at 2 years in the prison and you to forfeit the firearm. Did you understand that to be the plea?
Ma'am.
Defense?
Yes, it is, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
And did you sign it in both places? I'm sorry?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers State's Exhibit 1 and all attachments, Your Honor.
Okay.
All right, state two may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, this case is kind of an unfortunate one. Mr. Garza is a resident of Haven for Hope. He suffers from some mental health issues that have been checked out, and he is, I believe, competent and has been confirmed, but he does have problems related to prior injuries that he's had. And this particular day, this weapon was found downtown under the bridge by some other boy. And Mr. Garza picked it up to try to turn it in. He was literally on the phone with 911 on UTSA property whenever he was spotted with a gun on property, and that's what led to this. We've looked at pursuing this to a trial and all that, but Mr. Garza has been locked up for more than 6 months, and he has elected to take this plea. He was in possession. He is a convicted felon, so it meets the technical, allegations, but that was the reason that Mr. Garza has chosen to move forward with this case.
So a gun was discovered and he was calling the police to turn it in.
He took it, it was during the church under the bridge. He
Mhm.
went to use a phone from one of them, which is on the UTSA property, and was, as I understand it, on the phone when UTSA security saw him and came over. And here we are.
Well, my thing is, technically, is that a violation of the law? Yes. But is it a violation of the spirit of the law? It appears that it is not. So I don't know if there's proof of what he's saying or not. Based upon what I'm reading, it's not what's being said. I don't see it in the police report. So,
And with the nature of the offense and the people around, the witnesses, it's a challenge. That's what the defense is faced with, and that's the reason Mr. Garza has elected to.
and I'm assuming that's the reason why the state is proceeding on the lesser included.
as well as the minimum.
All right. Then the court will find you guilty of the lesser included offense. The court. All right, so here's my thing. We can go off the record. I understand why the state would proceed on the lesser included offense, and I may be overstepping my bounds here. But if what is being said is true, this just doesn't seem just to the court. I mean, if somebody finds a gun and they're picking it up and on the phone to call the police to say, hey, I found a gun, come and pick it up. Legally, is it possession? But this is not what this law is meant for. Am I wrong? And I understand state why you're reducing it, but do we have any proof of this? I'm telling you all, if there's proof of what he's saying, that he was on the phone, and it appears that there was the gun didn't have any, wasn't loaded or anything.
Your Honor, you do speak to a good point. If there is proof, there has been requests for things that have been alluded in the police report, things that would have corroborated.
Mhm.
The state has not been able to receive those things. There have been discussion with defense.
Mhm.
The state understands if it came to he said, we understand and believe the report. Things have been requested that we don't have. And
who would have these things?
we've requested specifically without, jumping around the 911. We do not have that. We cannot corroborate.
So where's the 911? Does the 911 not exist?
It's been requested and I haven't gotten word back. Now, we believe with the reports, we have the elements.
Yes.
Yes.
No, I mean, you do have the elements, and you actually have the elements for unlawfully carrying a weapon with a felony conviction, because he has a felony conviction. He was carrying a weapon. So I can sentence him now, or if you want to wait, I can not sentence him today, and they can see about the 911 call.
And Judge, I'll talk to Mr. Garza. This case was set for a couple of weeks from now. Mr.
Mhm.
Garza has asked me to push it up to move the case.
So, Mr. Garza, do you understand what's going on?
Just a little bit.
All right, so here's the thing. You're not allowed to possess any weapons if you have a felony conviction. And then there's some things, if you have a family violence, you're not, an affirmative finding of family violence, you're not allowed to possess any weapons either. And that's what this law is for, right? And if you, so from reading the police report, you're guilty, right? Because you had a weapon. But if you found a weapon, you picked it up, and you were calling the police to say, hey, I found this weapon, could somebody come and pick it up? To the court, that's not what this law was meant for. Because it's more danger to have a weapon just laying around where a child could pick it up or somebody else could pick it up than you're picking it up and calling the police and saying, hey, I found this weapon. And what I'm reading in the police report is that the officer comes up to him and he's like, yes, I do have this weapon, and yes, you may search my backpack and everything. So you can discuss it with your attorney if you want. We can recall it back in 2 weeks. Here's the thing. If it turns out that they can't get the 911 call and you still want to go forward with the 2 years, you'll have the 2 years and you'll get credit. So if we come back in 2 weeks and you end up getting 2 years, guess what? You're still going to get credit for the time that you were waiting for those 2 weeks. It's just you'll be at the Bexar County Jail and not at the prison. It's completely up to you. But for the court, I don't think, and I could be wrong. If I'm wrong, somebody correct me. I don't think that's the spirit of that law. So.
Judge, I'm in agreement with you. It's up to Mr. Garza.
Okay, so can you explain that a little better to me?
All right, so the state has offered you 2 years.
Okay.
I will follow that 2 years if the state, if they go and they're not able to get the 911 call because they say they've been trying to get the 911 call. If they are unable to get the 911 call, you'll still have the 2 years. So your waiting 2 weeks is not going to change your position as far as the agreement that's been worked out by your attorney.
We'll be there. We'll be back in a minute.
Or whatever whatever the court says.
I mean, if I have no other choice, but yeah,
No, you have choices. These are your choices. I can sentence you to 2 years today, or we can see if the state can find if the state receives, I don't want to say fine, if the state receives the 911 call, then if the state receives the 911 call, they may decide to do something different than what they're doing now, which may be in your favor. But at the end of the day, worst case scenario, you're sentenced to 2 years.
okay.
Wait 2 weeks. Well, it's up to you, but
You want to discuss it with him in the box and then just let me know. Indictment with your attorney, did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Stanton, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 7 months in the state jail facility. There's to be no contact with the complainant. I'm sorry, it's 7 months in the Bear County Jail under 1244. There's to be no contact with the complainant. The state will take in consideration 2025 PF 27168, 2025 PF 27169. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is our understanding, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State, any evidence?
State offers State's Exhibit 1 and all attachments, Your Honor.
No objection.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. Proceeding with sentencing,
Yes, Your Honor.
anything you wish to say on behalf of your client?
No, we just asked the court follow the agreement.
All right, do you have any children?
I do.
What are their ages?
I have a 3-year-old, and that's just it.
All right, and are you in the 3-year-old's life?
No, ma'am.
All right. Court is going to sentence you to 7 months in the Bear County Jail under 1244. Take in consideration 2025 PF 27168, 2025 PF 27169. There's to be no contact with Mariella, Maryela Hernandez, Crystal with a K, Yvette Garza, Gage Hartz, Harts, and there's to be no contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, you have issues. And if you don't take care of those issues, you're going to end up in somebody's jail. I read the police report, so there are drugs involved. If you don't get that handled, what's going to end up happening is you're either going to end up in prison, in jail, or either somebody's going to be identifying your body. When you're released from custody, if you can't find a place to help you with your drug problem, and I'm still here, you come back here, I'll pick up the phone and call to try to get you in a sober house, okay? All right, good luck to you, sir.
Thank you, Judge.
In State of Texas versus Christopher Scott Stanton, the defendant faced a state jail felony for unauthorized use of a vehicle. After waiving his right to trial and entering a no-contest plea, the judge found sufficient evidence and sentenced him to 7 months in Bexar County Jail, with no contact orders and strict conditions. The judge didn't hold back, warning him that drugs will either put him back in jail, prison, or get him killed, and even offered help if he chose sobriety. So tell me, was 7 months justice or a second chance wasted? If you want more real courtroom moments like this, like subscribe and
Criminal
share.
Trial Division.
I can do it, Judge.
Thank you. All right, the court is calling 2021 CR 2967, State versus Gloria Marie Carrizales. Can I have parties announced?
Duffy Pitlock for the State of Texas, Your Honor.
Horse dog bar for the defendant, Your Honor.
And are you Gloria Marie Carrizales?
Yes, ma'am.
All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Gloria Marie Carrizales who's placed on community supervision in 2021 CR 2967 for the offense of evading arrest detention with a vehicle on April 28, 2021 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 5. In Bexar County, Texas, the defendant, Gloria Marie Carrizales, did then and there fail to report to the supervision officer as directed for the months of December, January, February, March 2025 in violation of condition number 5.
How do you plead to that, true or not true?
Sure.
The state will waive and abandon the remaining violations, Your Honor.
All right, there are other violations?
The state does see a supplement.
All right, so did you review the supplemental motion to revoke community supervision with your attorney?
No, ma'am. I only saw one violation.
Okay. All right, did you review that with your attorney?
Yes, ma'am.
And it appears that the state is only proceeding on the violation that you were aware of. They're waiving any other violations. Do you understand?
Yes.
So the court is not going to consider any other violations, only the violation that you've pled true for if you wish to continue with your plea of true. Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, sentence you to 5 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is not, Your Honor. We're going open.
And state, what are you recommending?
The state is recommending you grant the state's motion, revoke probationer, but reform the judgment for 3 years, Your Honor.
All right, defense, what are you requesting?
Judge, we were pleading true. It's kind of a unique situation in this case, Your Honor, with an explanation. I think our first choice would be to just deny the revocation and terminate her unsatisfactorily. If I can give a little background, Judge.
Yeah.
And what I didn't have when we appeared before. When she pled into probation on this case and she was granted probation, she was in Bexar County Jail, but she had a blue warrant.
Mhm.
And so after she pled on this case, her parole was revoked.
Mhm.
And then she was in continuous custody until I have a document here, and it's just from the TDC, and which it also shows that she was in custody, Your Honor.
Any objection to the court reviewing the document?
None from the state, Your Honor.
All right, you may continue.
And so, Your Honor, in speaking with Ms. Carrizales, she did say that she did meet with the probation officer who came to the Bexar County Jail, but they were kind of perplexed as to the reason why she pledged probation when she had an outstanding blue warrant and parole issues.
Oh, usually there's a plea because they think if they were given probation on this and some sort of help, then maybe parole won't revoke them. Sometimes parole will look at that, not revoke them. Sometimes parole will.
In my conversations with Ms. Carrizales, she stated to me that when she did meet with probation, they had represented to her that if she got revoked, then they would seek to modify the probation to
Until start your discharge.
and obviously that did not occur, Your Honor, and I don't know the veracity of that situation or not, Your Honor. I don't. But you know, she's presenting herself here to the court right now. She's admitting that, yeah, once she was released from TDC, that she did not report. So it's just a unique situation. I mean, there is a situation in which there's confirmation that she was actually in prison. This is not a situation in which she just absconded and ignored her obligations to the court, Your Honor. There's not. There's I guess it's about 8 months or so left for the term of probation, Your Honor, and I think it's just that she was looking for some little reprieve from the court so that she could either continue on probation or court considered terminating her unsatisfactorily so that she can go ahead and actually kind of hit truth and is get on with forward with putting these situations behind her, Your Honor. And I think she also wanted to explain some of the things about the circumstances and also trainings and things that she has received since she was first put on probation, Your Honor.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Gloria Marie Carrizales.
All right, counsel, you may proceed.
Now, you had some things that you wanted to tell the judge about what you've done to change yourself since you were put on probation.
Yes, I did the cognitive thinking. I got 2 trades. I got my license in mechanic. I got my MVAC. I got my GED. And I took every class that I could to change my life. I got full custody of my son. And I just had a setback. I had a job. I was doing everything I was supposed to. I was taking care of my child. I was paying my bills. And I just want to get back to that. He goes back to school on the 18th. And I've already missed so much time with him. So it doesn't matter if it's probation or if it's termination, because I'm going to do it regardless. And that's really all I want to say.
Is there anything else that you wanted to tell the judge about?
And I mean, if it's the 3 years, I did the 3 years, and that's when I changed my life. And right now, being in custody, I'm trying to get to more classes. I'm just trying to do what I can to change my life. And like I said, if it's probation, I'll take it and I'll do it. If it's discharge, I'm gonna do it. It really doesn't matter to me. I just want to get on with my life.
All right, so any questions? I'm sorry, state.
None from the state, thank you.
So you've taken these classes, but what have you learned?
I've learned about my anger. I've learned about the way I was thinking and how I hurt people. And I've taken full responsibility for myself and my actions that I learned. I learned to be productive. And if I would have known that I could have just came here, I would have. And I didn't know that. But I mean, there's no reason why I should be in this situation. There's really no reason why, except that I broke the law and I'm just ready to take responsibility.
Probation? What is your released on probation according to this November 17th? I'm sorry, released on parole November 17th, 2024. And after that release, people have been trying to contact you. And what I can tell you is, I remember first starting out, probation wouldn't do all of this.
The person that I was on the probation at, I left that situation, and he's in custody right now for shooting me for leaving. So he wasn't telling me anything.
All right, and who is this person?
James Oviedo. I have a no contact order with him.
I'm sorry, James who?
Oviedo.
How do you spell the last name?
Oviedo. And he wasn't letting me know that probation was contacting me. Nothing. He didn't let me know anything.
And when did this shooting occur?
It occurred a month ago, or like a month and a half ago. I went to go talk to him and get the rest of my stuff. And as I was leaving, he was trying to keep me there. And when I was walking away, he shot me. And I went ahead and went to the hospital.
All right, and what's his date of birth?
It's April 12, 91.
All right, I'm going to think about this for a moment. Just give us a moment. Does anybody want to check into her story with this James Oviedo?
The state is confused. Was that the probation officer or like who this gentleman is?
He was the one that I was on probation at his house.
That is the residence where you were staying. So your probation he's not your probation officer.
9-0 State versus Cody Wade Harris. Could I have parties announced for the record for the state,
CourtTVLive for the state of Texas.
for the defense?
John Gilmore on behalf of Mr. Harris, Your Honor.
And are you Mr. Harris?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Harris, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes, I have, Your Honor.
Did you sign it?
Yes, I have, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, Your Honor.
Did you understand your charges possession of a controlled substance penalty group 1, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe that, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe that, Your Honor.
Mr. Harris, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state recommends deferred adjudication. There's to be restitution of $60 to the Bexar County Laboratory for testing. There's to be restitution of $60 to Texas Department of Transportation. There is to be a judgment satisfied in 2025 CC 000685. A TAP evaluation, follow those recommendations in MRT. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No motions, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years and there be 100 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plea? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
State offers states Exhibit 1 and all attachments at this time, Your Honor.
No objections to that, Your
All
Honor.
right, state you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court would defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Just very briefly, Your Honor. Mr. Harris is a 51-year-old farmer. He made a serious error in judgment 2.5 years ago. He's made a lot of significant life changes since then. Most importantly, he met his significant other, Jessica, who's present in the courtroom in the red back there, Your Honor. She's been a positive influence on his life, positive influence on getting him through this and following all conditions of release. They're actually getting married in September as well. And they both look forward to getting this behind them and to proving to the court that Mr. Harris can be a contributing member to society.
All right. So if you're drug tested today, what are the results going to be?
Good.
All right. So when's the last time you used?
Probably the day of, I mean.
Right. And so you went into the hospital and what happened? Because it shows here you were arrested.
I don't recall any of it. Your Honor, I remember leaving and that was it.
All right. So how do you maintain sobriety?
I do a lot of work.
All right. And what do you do?
I farm, I work for a man with a trucking business and it's 8 days a week and doesn't give me any time to.
8 days a week?
Well, it's
Doing my math. I mean, there's a day Deputy Laura, Deputy Mejia, there's a day we've been missing.
You have to
Do we need to add that to our schedule?
You need to understand the man I work for.
And so when you say you farm, what do you farm?
Been combining Milo and been cutting a lot and baling a lot of hay here last.
All right, what is Milo?
It's maize. It's just a grain, kind of like corn.
Okay,
It'll make you sneeze and make your allergies itch.
okay. Do you have any children?
Yes, ma'am. I have 3 girls,
And what are their ages?
30, and the twins are 30, and then the youngest one is 22.
All right. So when you do have free time, how do you spend that?
I spend that with my family and my grandkids.
Okay. All right. And how's your grandchild?
I've got 6 of them there, anywhere from 7 to, I believe the youngest one right now is about 4 months.
Okay. And are you here in Bear County?
I live in Wilson County. Yes, ma'am.
All right. So is there going to be a request for a transfer?
Yes, Your Honor, I believe so.
And how, I'm trying to learn geography of Texas. I know I should already know this, but I don't. How far is Wilson from Bear County?
They connect counties.
Oh, okay. So,
Actually, I work in Bear County.
all right. So do you need a transfer to Wilson?
If you will be concerned, yes, if not, then.
I come into San Antonio, or Bear County, for my job, but I also go farther south also, so I wouldn't have a problem with coming to Bear County or.
Okay. All right. This is what the court is going to do. 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, restitution of $60 to Bear County for laboratory testing, $60 to DPS, judgment satisfied in 2025 CC 000685, proof of employment within 45 days, no employment as a home health care provider or with minors. I'm going to do the transfer to Wilson County. And I'm going to want field visits 1 time per month for 5 months. There's 100 hours of community service restitution. I'm going to order the parenting classes since you're seeing grandchildren a lot. Once you complete the parenting classes, the community service hours will be deemed satisfied. There should be a TAP evaluation out of custody. Follow TAP results. Although probation, if they recommend inpatient treatment, we'll start with outpatient treatment. Is there anything else, probation? 100. Is there anything else you need from the court to be successful?
No, Your Honor.
All right. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, so we can go off the record. Here's the thing. Your case, I see it involved perhaps a DWI. You say you have a wedding coming up. You're one of those people, you cannot drink alcohol. So at the wedding, you can't do that champagne toast. If you don't want anybody to know that you're not really doing a champagne toast, they have the Welchers that looks like champagne, I think. So there are other things to do it. You cannot backslide now. If you backslide now, what's going to end up happening is there could be a violation and you're looking at potentially 20 years in the prison. So I know you don't want to see that happen. In this court, when people are on probation, communication is key. If there's an issue, let probation know about it. If you feel that you're about to use, call probation. What they're going to do is they're going to set it for a compliance hearing, and we're going to see if we can get you back on track. Everybody wants you to be successful at probation. Otherwise, the state wouldn't have offered it, you wouldn't have accepted it, and I wouldn't have gone along with it. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, ma'am.
Thank you.
Yes.
In state of Texas versus Cody Wade Harris, a 51-year-old farmer faced a second-degree felony drug charge that could have meant up to 20 years in prison. Instead, after a no-contest plea, the judge granted 4 years deferred adjudication, strict drug testing, treatment, community service, and probation, making it clear this was his last real chance. The warning was simple: stay sober, communicate, or risk losing everything. So tell me, did the judge give mercy or pressure that saves lives? Drop your thoughts below and like, share, and subscribe for more real courtroom moments.